Hi, friends. Hello, hello. Today we're going to have live with me, immigration lawyer Alena Shautsova. We're going to discuss the most interesting recent USCIS updates. Today will be a little bit different. I'm going to talk to you about different types of cases that you are filing with USCIS and what is happening with those cases now. So if you are interested in this topic, please stick around. Let me know where you're watching from. As always, say hello, and of course, I will be answering your guys' questions live. So, prepare your questions, type them up in comments. Let me know if you can hear me. I know that people who are watching me on TikTok can always hear me, but for some majestic reason, people who are watching me on Facebook and YouTube sometimes cannot. So, if you guys can say hello and type in comments, if you can hear me, it would be extremely, extremely helpful. And of course, don't forget to ask your questions, send your hearts, send your likes, and share, of course, if you can. As I said, today we're going to be talking about USCIS. USCIS is the main immigration agency in the United States that is handling what we call affirmative applications and petitions. Affirmative means that you are not in court. When you are in court, then it's called defensive applications, right? Like defensive asylum, for example, when you have to defend yourself. Hi, King of the South. Hi, Sarah. Hi, Robert. Hi, DT Puck. Hi, Freedom. We're going to talk about the dates on ISIL green cards, of course. Hi, guys on TikTok. Hi, Ali. How Boo. How Elizabeth. Say hello. Don't forget to let me know if you can hear me. If you're watching me on YouTube and Facebook, type up in the comments if you can hear me well. Give me a thumb up. And of course, type up your questions. Type up your questions, right? So let's start. The first case type we will be discussing concerns a very important application, Form N400, something that you're going to file with the USCIS if you are seeking to become a US citizen. All right? Application for naturalization, N400. Well, the good news is that if you're filing it now, after Trump's administration took office, it's probably going to take you only 6 months, maybe even less, to be called for an interview. What is the bad news? Thank you very much, King of the South, to let me know that you can guys hear me. What is the bad news? Well, it's not particularly bad news, but it's something that, of course, became much stricter during this administration, is the fact that government will check how you received your green card. Even if you are a perfect English speaker, you complied with all the requirements, you passed that test, you did everything perfectly, you don't have any criminal charges, they will check if at the time when you were granted that green card, you qualified for it. Please be aware of that. It means that if at the time of your green card application you were not entitled to it, what's going to happen? Your N400 will be denied, and after a while, maybe a couple of months, you will be placed in removal proceedings. That's the policy of the new administration. Let me give you an example. Somebody stated that they were not married, but they were married, and their parent filed for them as an unmarried child. They were married, they concealed this information, they got their visa, they came to the United States. Now it's time for them to apply for citizenship. And sometimes this person even tries to sponsor the spouse into the United States, revealing to the government that, they were married at the time when they received the green card, meaning that they did not qualify for that green card because in the paperwork they were unmarried. So what's going to happen to that person? Their application will be denied for N400. Another example, somebody received a green card based on employment. When the green card was issued, the priority date was not current, but the officer who was processing cases made a mistake and stated that it was current. Now, believe it or not, the government now, many years later, is going to again check if the priority date was current. And if they find out that it wasn't, they will deny N400. Thank you guys for the gift. Thank you very much, Sofiane, for a very nice gift on TikTok. That's what's happening. Another, the last very common example. You filed for N400, you left your address history. You received your green card based on marriage to a US citizen. But your previous application forms had a different address history. Now the officer reviewed your cases and found this out. They will accuse you of false marriage. I'm just letting you know this. So please, please, when you're filing paperwork, know about this and be very, very precise and accurate. Mistakes may lead not only to a simple denial, but to a full-blown deportation proceedings against you. Second type of cases. Oh, and one more thing. Currently, the government of the United States are focusing on waiver cases. When a person says that I cannot speak English, they issued not so long time ago guidelines saying that they will be double checking everybody who qualified or tried to qualify for citizenship based on that waiver exception that they didn't have to speak English. Just so you know. Okay. All right. Now, second type of cases, SIJ cases, special immigrant juvenile cases. Well, under the law now, they have to be processed within 180 days. But again, Trump's administration stated that there is a lot of abuse with SIJ cases, and they will pay very close attention to those cases. It means that number one, you have to expect delays. Number two, they will be double and triple checking you to make sure that you are not lying in your paperwork. Okay. Number three, marriage cases. Marriage-based green card cases are processing super fast. 3 months. Some people online say 2 months. They're skyrocketing. They're so fast. But what happens here is this. I wouldn't say it's a trap, but it's something you need to be aware of. When you're married with your spouse for less than 2 years, you're going to receive a conditional green card. Just because you received this first green card super fast and easy does not mean that your eventual green card without condition is going to be as easy to receive. Make sure that within this 2 years or for this 2 years, you're going to be collecting evidence of real marriage. You're going to stay on top of your paperwork. Why? Because when you receive that conditional green card, in 2 years, you'll have to file for removal of condition. And here is a surprise. If the government denies your application, they must place you in removal proceedings. So by processing this green card application super fast, what they do is that instead of 10-year green card, they're going to give everybody 2-year green card. Why? Because they're sure they're going to get you 2 years down the road. Just know about this. I-140 employment-based cases. So everything is good with those cases. I cannot complain about anything apart from one thing. Just because you received I-140 approval doesn't mean you're going to get the green card. What started happening recently is that people who received I-140s, employment-based petitions for green card approvals, are being called for interviews. And after those interviews, what's happening? If the government believes that your qualifications for I-140 were exaggerated, they're going to try to revoke it, even if they approved it a couple of years ago. Just know about this. So when you go for that interview, don't think it's an easy breezy interview and nothing's going to happen to you. You just have to show up. It's a formality. No, they will try to challenge your qualifications for the job, for the immigrant category you were approved in to begin with. And finally, asylum-based green cards. Lots of questions about this. In fact, there is one of those questions right here. Let me just highlight it. Here we go. So what's happening with that is this. Government issued new guidelines saying who they will be calling for interviews. And basically they're saying that if they believe you committed fraud during your asylum application, misrepresented your identities, misrepresented certain facts, the government cannot verify your identity or some facts, they will be calling you for the interview to take a sworn statement from you. But it also means that most likely the pause on those asylum cases processing will be lifted. Why? Because now they know what to do and how to approach this super duper vetting procedures that Trump said will have to be applied. Okay, so that's what's happening with asylum green cards. Now, if you guys have questions, and I know you do, I'll be answering them live. Thank you very much for joining again. Please share this show. Send me some questions. Let's see. Hi, DTPEC. Have someone received green card based on asylum recently? Well, my clients received those green cards prior to this announcement that there will be a pause. So I cannot tell you if anybody received it within this next, within this past maybe 5 days since the announcement came out that there will be calling for interviews certain green card applicants who received asylum. I unfortunately do not have that information. Hi, Veronica. USCIS sent an RFE asking for police records and letters from friends and community. I was able to get lots of good letters and stuff. Will they approve my T visa? I have a couple of dismissed charges. Veronica, unfortunately, I cannot tell you what they will do. Okay. All I can tell you that when you're dealing with an RFE, try to be as precise as possible. You don't have to testify against yourself, of course, but you would like to legally give them sufficient evidence, that will satisfy the request for the RFE. Typically, usually, if the charge is dismissed, in most cases, you will be absolutely fine. But you need to know one thing: under immigration law, even if the charge is dismissed, but a person did suffer some sort of a punishment, they may still be considered as convicted. Okay. So let's say somebody is accused of a small charge that whether a person was actually found guilty of or not wouldn't really matter for immigration purposes. Then it doesn't matter, and the government is not going to ask you for any waivers, and the T visa will be approved. But if a person was accused of certain conduct that if a person were convicted of or can be said that they're guilty of, and it does present a problem for immigration, then it's a totally different story. So please work with a lawyer who's going to properly guide you, okay? And also probably will guide you what to do if you're called for an interview of any sort to testify about the charges, even though I do not know anyone who's been called for an interview in connection with a T visa or a U visa today. But it doesn't mean that it's impossible, okay? High space. Does the common law marriage count when filing I-45? That marriage was in DS-160, Russia. After that marriage, you have another legal marriage. Well, here is the thing, space. As there is no legally recognizable common law marriage in Russia, it means that you will not be able to obtain common law divorce from that marriage. It means that government is going to accuse you of misrepresentation. Okay, and you have to probably be ready to file for I-601 immigration fraud waiver. I talk about this problem all the time. I talk about it in my many videos, because what happens here is this. If the government accepts your position that you were married, they will demand that you produce divorce certificate, which you cannot produce. If, however, they accuse you of fraud, saying that you boosted your non-immigrant visa application, saying that you were married when you were in fact not legally married, then at least you have a chance of filing for the waiver and resolving this situation. Okay, so that's what's going to happen with that particular problem. I just had a video about this actually. Okay, and if you guys need my help with any of these immigration issues, please call my office, make an appointment, and we're going to see how we can help you. 917-885-2261. And if you're watching me on YouTube or Facebook, there is this line at the bottom of the video that gives my contact information. Right? Hi, Kingsley. A friend of mine was asking if she wants to marry a US citizen while she is on asylum process. Will that stop the asylum process, or how does it go? No, guys, marriage to a US citizen by itself does not stop any immigration process. But if your friend would like to, using that marriage, receive a green card in the United States, we need to know if she's adjustable, if she can't do that. Sometimes people can qualify for asylum, but it doesn't mean that they will be able to qualify for adjustment of status based on marriage. Two different things. But no, it doesn't stop the asylum process. All right. Thank you very much, Space, for your gift. I've heard I don't have to pay $1,400 when filing for a green card after asylum win in the court. I don't have such information at all. All right. The fees were changing. There is a category of people who doesn't have to pay filing fees. That would be refugees. They don't pay. Okay. But if you would like to check who has to pay, this is what you do. There is something called USCIS Asylum Fee Calculator. You're going to put in your form I-45, and that calculator is going to tell you if you're adjusting based on this, this is your fee. If you're adjusting based on that, this is your fee. This is how it works, okay? So what's going to happen is that you will have to verify at the time of the filing what your fee is, all right? That's how it works. Let's see. We're going to answer some questions from very patient, very nice TikTok followers. You guys are my followers, right? Let's see. Hi, Taki. What's the difference to response and error fee between mailing and uploading on USCIS online? I don't think there is any difference. So if you can upload online, you're going to have proof that you submitted the answer. I don't think there is much difference, to be honest. Can I use deemed parole for INA 245 argument? I'm not sure what deemed parole means, but if you were paroled into the United States and you have proof of that, typically parole, let's say under 212D5, maybe that's what you mean, can be used for adjustment of status purposes. Parole under 236B cannot be. So we need to know how you were paroled, for what purposes, okay? All right, hi Shay. I see part of your question, but I don't see the rest of it. And the part of your question sounds like this. We only have a lease and a bank account together and a few pictures. We have been married for 11 months. I guess you're asking something in relation with evidence in support of the argument that you have a real marriage. All right, so under the guidelines from USCIS itself, that comes from USCIS, if you're newly married, but you would like to file your case, you should submit some evidence, and it seems you have some, but you don't have much. So you can produce affidavits by a US citizen or a green card holder, people who know of you, of your marriage, and if they provide good details, sufficient details as to the marriage situation. Maybe these people who are writing these affidavits spend time with you guys often. Maybe they know you in professional capacity, maybe they're your neighbors. Then it will also count as evidence in support of bona fide marriage. And very often they pay a lot of attention to these affidavits. I find that affidavits by not your family members works the best, okay? Because government basically says this, well, look, why would we, the chances are that the person who's not related to you, right? Why would they lie to federal government? So that's how they think, all right? All right, let's see. What other questions we have? I have Siege EY, married to US citizen. Can I use parole 245? No, you won't be able to. Oh, you mean the parole that you received when your Siege was granted? No, you can't. That's a different situation. I don't think you can. Because you were actually not physically paroled at the border, right? It was just you were paroled for, it's more like a deferred action, right? That's what it is. I've never heard of that, just letting you know that it can be used as parole that satisfies 245 adjustment requirements. My asylum granted and I have I-45 pending. Is it safe to travel internationally? Well, you will have to have a document to do that. Don't go back to your home country, okay? But if something happens to your case while you're traveling, you may not be able to come back. So if I were you, I wouldn't travel at this time. I'll be honest. I just would not travel at this time. Because I have this people who call my office and they say, listen, I thought I had a green card, a temporary green card. And when I was away, something happened, usually like a denial. And previous administration, they would allow you to enter the United States and file an appeal, a motion to reopen. But this administration is different. They're like, no, your status was denied, and we're going to place you in removal proceedings. And you figure out with a judge how you're going to go about your status. So if you have something pending, I wouldn't do that. Okay, just so you know. All right, let's see if we have more questions from TikTok. VAWA is on for last 9 months, but no work permit yet. But can I apply for a U visa? I'm a victim. Yes, of course, you can have an application for a U visa. It's not going to affect your VAWA, all right? So you'll be absolutely fine, all right? High space. Do I have to first file I-45 and later wait for the medical exam invitation, or can I go ahead and pass the medical exam? No, these days you have to submit the medical exam with your I-45. That's the new rules. We no longer wait for the RFE on medical. You have to submit all together, okay? The good news, you don't need to have COVID vaccines anymore. Hi, Paula. Will a juvenile case that happened 13 years ago and got expunged affect my I-45 decision? Had interview. Did you disclose it? It shouldn't. Under the immigration law, juvenile conviction, if it was a juvenile conviction, should not affect the outcome of your application. But knowing that, I have to tell you that this government started asking for the records of those juvenile situations. And you have to show that the record was expunged and it doesn't exist anymore. So take it from the court, okay? The proof. So it's very important that you do that, okay? But typically, there should not be any consequences if you were processed as a juvenile. Hi, are some I-130 based interviews being waived? Hi, Selema. No, they're not being waived, but they are scheduled very, very fast. Hi. Thank you, Genrix, for sharing the live. Hi, Dicky Boss. Hi, Kakar. My asylum granted. All right, that's the travel question. Yeah, if you don't have to, please don't travel. I can't guarantee you that everything will be safe. Typically, it should be, but because you have something pending, I wouldn't. Hi Eric, any news or updates with DACA recipient detained in Texas? Is it safe to travel with DACA still? Well, you know that the government of the United States stated that DACA people should say self-deport. I think this news was last week or 2 weeks ago, right? So instead of giving them status, they said, well, by the way, we want to remind you that DACA is not status. And rather than staying here, you should self-deport. So, do you think it's safe? I mean, it's a status, and that's how every administration treated it. But this administration doesn't really follow the traditional patterns of acting. I don't know how to say it politically correctly. So, anything can happen. By traveling, you are exposing yourself to a higher risk of being detained. Why? Because when you travel, you may meet ICE agents who very often are in airports or train stations or bus stations, and you are increasing your chances of having this encounter, and encounter may lead to detention. Are you going to be released from the detention? Most likely, yes, if they don't take your DACA status away. Okay? So, if I were you, again, I would be very careful these days. All right. Hi, Jester Cruz. Pending asylum appeal with the BIA. Can I still work while I'm waiting for my 3-year waiver for I-1? I'm not sure what I-1 is. But can you work? You should be able to work usually when the appeal is pending with the Board of Immigration Appeals. My wife and I applied for, unless did not qualify for work permit, your clock stopped or something like this, but usually you should be able to get the work permit and work yes. Hi Abdul, my wife and I applied for a green card using the same application, I-45. Is this normal? Your wife and you applied. Every applicant for a green card must file their own I-45. All right, so I'm not sure if you used the same, meaning like the same form, then it's not possible. If you use similar form, that's possible. That's the form that's used to file for a green card, but I do not know your guys' circumstances. Okay, not sure what's happening there. All right, let's see. Okay. Can a 212H be revoked? Can I travel with a green card and I-212H? I've never heard of 212H thankfully being revoked. Don't give them any ideas, please. All right. I never heard that it can be revoked, honestly. Why? Only I guess anything can be revoked, but there have to be very strong evidence, usually evidence of fraud for that. All right. I've never seen anything like that happening. So, and usually if you have I-212H waiver approved, you are safe to travel, to file for citizenship. I had cases like this, we never had any issues. But to be fair, well, they were with previous administration, and maybe something changed, but not to my knowledge. And no lawyers that I know of shared anything that would suggest otherwise. Okay. All right. Let's see. What should you advise? What should you advise me? Hi, Muhyiddin. What should you advise me to do? I have a pending asylum interview with USCIS. I'm not sure what your case is or what your situation, but typically any lawyer would advise you to appear for that interview, okay? Or schedule it if you have very good reasons for that. And you need to prepare for it very well, right? You have to update your case. If your case has been pending for a while prior to the interview, guys, you are expected to produce updated statement, updated country conditions, updated evidence, updates to your form I-589. You have to do that, all right? Okay. Hi, Kingsley. When an asylum is granted after 9 years of applying, how many years can the asylee wait for citizenship? Oh, you will have to wait for 5 years from the date that's printed on your green card, resident since. So you first have to get a green card. You're going to see that the date of your green card will be rolled back by 1 year. So usually an asylee is going to wait for 4 years since they received the green card, prior to them filing for citizenship. Okay. All right. Let's see. Hi, Paul. With August 1st memo, is it safe to file I-130 if you are undocumented? What do you think, Paul? Tell me. If you know that the government stated that if they encounter somebody without documents, undocumented, because a family member filed I-130 for them, they may place you in removal proceedings. Is it safe? It means that they can place you in removal proceedings, and you have to understand the risk. However, risks can be different. If you have a strong case for cancellation of removal, it's one risk. If you don't, it's a different risk. You understand? So you look at this situation this way. If you are undocumented and you're filing for I-130, I-130 doesn't give you any status. What do you want to get out of it? Is your plan to move on to I-601A? All right. Even if they try to place you in removal proceedings, so they place you in removal proceedings, if you don't have 10 years necessary to file for a cancellation of removal, right? Some judges will allow you to go through I-601A route if you qualify for it, if there are equities, okay? So just understand the risks, but I cannot tell you that it's safe. It's nothing safe anymore, all right? And if your application is denied also, they will issue NTA. So nothing is saved, unfortunately, right? Okay, let's see. Hi, Mark. How long does it take for a VAWA to get approved? Mine took 1,220 days. Interesting. So it's how many? It's like 3 years? Well, it usually takes about 2.5 years. Okay? That's what it is. Hi, Lofombo. I had a misrepresentation, and now I'm having a pending VAWA. All right, so if you had been accused of misrepresentation in connection with immigration benefits, it means that you may need a waiver down the road. Okay. Hi, Angela. I have an asylum interview. My husband come 1 week after my interview to United States. Can I still include him? Can you still include him up until asylum is decided affirmatively? Of course, you can include him, but you have to go about it properly. Okay. You have to contact the asylum office. There is a guidelines on USCIS website how to do that. Hi, God's Masterpiece 25. Is it safe to go to a USCIS interview if you're on removal and have a pending renewal TPS? It's a very interesting question. It basically depends on the jurisdiction. I've noticed that it's typically safe if you've never had any criminal encounters. Okay? In New York, even New Jersey, they don't arrest you, even if you have a removal order, if you did not have any criminal trouble. If you did, it's a whole different story. All right? But go with an attorney no matter what, right? You have to have a lawyer with you. Okay, let's see. I came as a unaccompanied minor, I guess, filed asylum. I don't have evidence with me. Do I have any benefit for being an unaccompanied minor? Nah, not really. You still have to follow the rules as everybody else. Not having evidence per se, paper evidence per se, does not disqualify you from asylum. There are other things, there are other ways you can prove your case, okay? sometimes real asylees, refugees, they run for their life, they don't have anything with them, and their cases are still being granted. It's about credibility in your situation, whether they believe you or not, right? The circumstances. So that's what's happening. Prepare very well, explain what happened. Under Real ID Act, explain why the evidence are not available. I guess they will take into consideration the age and the circumstances too, all right? If you're very young, but you mentioned unaccompanied minor. Have you tried going for SIJ, Special Immigrant Juvenile Status? I do not know how old you are, but if you're under 21, you may still consider it. Okay? You may still consider it. Okay, let me answer one last question. Let's see. If you guys have one last question. If not US, high space. It's not really a question, it's hypothetical. If not US, what country do you choose? For a living, I don't know any other country, any better country. We have our issues, but they will be resolved, guys. Thank God we have elections every 4 years. So I'm not really worried about the United States being completely broken in the end. I don't think it will happen, not now. And there are no alternatives, really, unfortunately. Unfortunately, I still think United States is the best country in the world. Just because we have a temporarily hiccup situation, all we need to do is to learn how to navigate it, right? Be smart about that, be prepared, be very well prepared. But I don't think that there is a better country than the United States in the world. All right, let me see. Thank you, Toyo. Very nice to meet you as well. Dennis, good morning. Let's see. Thank you very much, guys, for your questions. Okay, so the question about filing together or simultaneously, my husband and wife for adjustment of status, the question is about whether or not the government is going to approve those applications at the same time. There is no guarantee that they will. Very often, depending on your personal circumstances, they may approve one of the spouses and not the other. All right? So it doesn't mean that they will approve at the same time. You just have to know that. Okay? Are I-601A waivers taking longer under Trump's second term? No, guys, no. I-601A waivers started taking longer under Biden. It wasn't Trump. All right? First, they were saying they were taking too long because of the COVID, right? They said COVID. But COVID disappeared, and those I-601A waivers are still taking forever. So it's not here, I cannot say that it's Trump's fault. I'm going to be honest. When it's this administration's fault, but I think I'll tell you. But when it's not, I cannot say it's their fault. Something is inherently wrong started happening to I-601A waivers. They were designed by Obama's administration to be processed quickly. 3-6 months and you resolve your issue. Now it's taken 2.5 years. It's insane. It defeats the purpose of the waiver, right? You're going to have a whole generation of kids grown up by the time this waiver is resolved. All right, last question. Are there cases where green card holder files for spouse outside of the United States and is approved in 2 years? Of course, absolutely. But it doesn't mean that your priority date is going to be faster, okay? It doesn't mean that. The priority date, you cannot do anything about the priority date. Only that the green card holder should become the citizen. That's the only way to move that cases up, all right? That's what it is. Well, guys, thank you very much for joining tonight on this beautiful Friday night, not even afternoon. Thank you for joining. Thank you for sharing. Thank you for your questions. I hope you find this video helpful. So please like, share it. Don't forget to follow. Thank you very much for all of your gifts. Thank you, Umanaya, for your gift. Thank you. And of course, please Join my social media family so that next Tuesday night we're going to meet again and I'll be answering your questions and sharing news. Do you think we're going to have an immigration news happening over the weekend and Monday? I bet we will. It happens every week now. So thank you very much. Stay safe.